Very good morning to all of you. It's so very pleasant to be here in the morning and to see all of you all decked up for today. I mean, I have felt very comfortable in Assam, Gauhati, of course, that's the principal seat. But here also, for the last 2 nights that I'm here, I found it to be very congenial, very good. Let's see how we proceed further. All right.
On behalf of the High Court Bar Association,
Yes.
I'd like to welcome the Lordship to Kohima.
Thank you so much. Thank you so much. Yes.
For admission, item number 1.
My Lordship.
Yes.
Lordships, last Wednesday, that is 20th of August, a division bench of Justice Kalita and Justice Magunda heard identical matter, my Lord, criminal matter. Same question of law, and they have reserved the decision, my Lord.
Doesn't matter.
Therefore, I pray that this matter may be taken up after the division bench delivers its judgment, because if the single bench has to choose conflicting decisions of this honorable division bench of this honorable court, then, my Lord, it may give an unwanted situation, a situation that has been deprecated in Banasati.
No, the situation would not be so unwarranted. You see, there are conflicting decisions otherwise
My Lord,
on record.
my Lord,
But then we go by Supreme Court.
my Lord,
That's the law of precedence. I mean, nobody can deny that.
my Lord.
So therefore, we have a judgment from Supreme Court which is not in your favor, I must say. Yes. It's not in your favor.
My Lord.
There are 2-3 things that I have noticed in the judgment,
My Lord.
and therefore it requires to be interfered with. But why do you ask us to go for it? Give you an adjournment only because the judgment is reserved.
My Lord, because if, like I said, my Lord, the division bench held differently. And Lordship, in a similar matter, the division bench has allowed and an appeal was preferred by the state before the Supreme Court.
That we are aware of.
My Lord, my Lord.
That we are aware of. The question of law was left open.
My Lord.
And otherwise also, unfortunately or fortunately, I am also signatory. In fact, I am the author of a judgment which goes against you. Of course, in a different jurisdiction. Of course, in a different jurisdiction, Mr. Counsel.
My Lord. My Lord.
Mr. Santianga, tell me one thing.
Lordship.
Isn't the facts out here
Lordship.
similar to the facts which were there in the Achumi's judgment?
No,
Because-
my Lord.
Yes, because of the fact that in 2019, these respondents or the petitioners
Lordship.
were fixed and they were released.
Yes, Lordship.
And in 2021,
Lordship.
you woke up.
Lordship.
Isn't it the same thing which was held by Justice
Lordship,
Emma?
I beg to differ, my Lord. Because in Achumi's case, the wife of the deceased employee approached the court after 13 years after the demise of the
Now,
husband.
does it make a difference?
Now, Lord,
Conceptually, Mr. Santianga, it doesn't make a difference.
Lord,
See, whether it is a delay of 2 years or 13 years,
Lordship.
whoever is the petitioner, because it was with respect to the particular employee who died,
Lordship. Now,
situation remains the same.
being a model employer, my Lord,
Apart from that, see, forget about that judgment of Supreme Court.
Lordship,
Delay aspect, we might not give that importance.
my Lord.
But otherwise also under the rules, there are 2 OMs, one of 2004, the other is on a different plane of 2015,
Lordship.
and you don't fit in anywhere. That's the whole difficulty.
The-
In 2004 thing, you're not, there is a seniority issue. There are people who are senior to you
Lordship,
before you were released.
Lordship.
And in 2015, you don't fit in because you are not in the fixed scale of pay.
But Lordship, if we take a closer look, my
Yes.
lord, the pay scale, Lordship, scale of pay, Lordship, it is being awarded in a pick and choose manner, Lordship. And Lordship, similarly situated, 380 employees, they have been granted scale of pay.
That's
That's
not factually correct.
It is factually correct,
No.
my lord. I have annexed the
The additional affidavit before the writ court we saw,
Lordship,
and we have also seen the response of the state.
Lordship.
So that is not factually correct.
Lordship,
No,
but
there were people.
it is
So
an RTA reply given to me by the furnished to me by the state, my lord. It is not my.
no, that RTI reply is
not a
all right.
document that I manufactured.
That's no. We are not commenting on that. We are not talking about the genuineness of your claim. But then the difficulty is that 2 years he had retired, and then he was not in the scale of pay. Everybody who has got
Lordship.
would not be similarly situated. Would not be similarly situated. Very well, because this is the first day, we might not, put you to much discomfiture, especially when you have pointed out that one of the bench has reserved the judgment, but we can't postpone it forever.
My lord.
It states.
Hmm?
It state because there is a direction to legal bench.
Will I put it?
States.
Yes, what do you have to say?
Lordship, with regard to what my learned friend has just stated, the Supreme Court dismissed the SLP.
No, that
However, the question of law was left open, so it is this honorable court may take into consideration and heard the matter, Your Lordship.
we have heard all the writ petitions have been heard together. We have heard Mr. Santianger,
My lord.
names you will take. We have heard so-and-so and Ms. Shukre for the respondents. The issue involved in all the writ petitions is whether the work charged employees governed by Nagaland Work Charge and Casual Employees Regulation Act 2001 could be regularized when they don't fall in the category of the scheme framed under the Act of 2001. It has been brought to our notice that there are two office memorandums
In 2004.
under the Act of 2001. First of the Act of 2000, Section 12 of the Act of 2001 merely provides for a scheme for absorption of service, which inter alia mandates that the state government may draw up a scheme for absorption of service of work charged employees into regular government service. On the aforementioned enabling provision, the state government brought forth office memorandum dated 22/9/2004 and later office memorandum dated 17/3/2015. The OM of 2004 clearly provides for 50% of all regular vacancies of similar nature arising in a year to be reserved for regularization of work charged employees, and such regularization is to be considered on the basis of seniority cum merit without any bar with respect to age of the employee, except that he would not have attained the age of superannuation. The OM of 2015, however, provides for regularization of work charge employees who are in a scale of pay and who have completed 30 years or more continuous service as on 1/1/2015. In most of the cases, in most of the writ petitions, the employees concerned had served for the stipulated period of time, but none of them were in a regular pay scale. Mr. Santianger, while defending the judgment impugned in the present petitions, in the present appeals, has submitted that the government, in the garb of exercising its powers under the OM, have been cherry picking the employees, and many persons similarly situated were treated differently. First up, after their retirement, they were given the benefit under the scheme, leading to their being paid post-retirement dues. First up. However, we find that in some of the writ petitions before the learned single judge, the employee concerned had already superannuated, and during the entire tenure of their engagement with the department of the government, there was no claim put forth.
Lordship, if I may, my lord.
Just a minute, we have said only for one, so therefore in some of them. Let me complete.
My lord.
What is it? What did I say? Put forth their claim for regularization or for putting them in in fixed scale of pay, which could only have been given after they were regularized. Instances have been cited where, taking into account the fact that employees who had been serving the government for so many years would be left completely high and dry, decisions were taken by different benches with respect to their regularization, even post-retirement. However, in one of such cases, though the Supreme Court did not upturn the judgment of the single judge, but left the issue open. After having argued for some time, Mr. Santianger, learned counsel for the appellant in so-and-so, submits that on a similar issue, in a different appeal, a division bench, after hearing the arguments, has reserved the judgment.
Appeal 3 of 2024.
Has reserved the judgment. And in case judgment is pronounced in these set of appeals today, there would be a possibility of an anomalous situation being created. We, therefore, in all fitness of things, deem it appropriate to admit these set of appeals for final hearing. But we also deem it necessary to stay the operation of the judgment in each of the cases till the final disposal of this appeal.
My lord.
Let these let these appeals be listed for final hearing. We give a date after 30 days. Final hearing on so and so date.
My lord, my name may also be reflected in for a respondent would to the principal accountant.
Give your slip, give your appearance slip, it shall be reflected.
Your lordship.
Okay.
Lordship.
Think of that much.
Yeah, it is like yeah, it's
But this doesn't.
For admission, item number 4.
Yes.
Maybe my lordships.
Yes.
IA 131 is for condemnation of 8 days of this 12 days, lordship.
Has notice been served?
Yes, lordship.
Any objection? 12 days, we are inclined to condone the delay.
No, your
I number so and so. We have heard the learned counsel for the parties. For the reasons stated in the application, the delay of so many days in preferring the appeal is condoned. The application stands allowed. You can address us on merits.
Lordship, 152 is for stay of the impugn order.
Yes. Yes.
Lordship. My lord, will kindly come to page apart from the infune order, here, what has happened is, Lordships, the respondent number 5 was appointed through Bedgo.
Who appears for respondent number 5?
My lords.
All right. All right, yes.
Yes, Lordship. What has happened is, here in Nagaland, there is a scheme for appointment in great purpose for the landowners, Lordship.
Yes.
So, my lord will kindly be pleased to appreciate that 3 individuals, they donated their individual lands for establishment of the government office, PWD R&B,
Yes.
EE office, Executive Engineer office,
Hmm.
that is established, that is on the land of Ayami clan. Ayami clan, there is clan system, Lordship.
Hmm.
So Ayami clan donated their land
Hmm.
for establishment of Executive Engineer EE Apoiz Division Office. Whereas we, the Chopi clan, donated the land for establishment of subdivisional office under the Executive Engineer Apoiz Division. In between, there are more than 2 kilometers distance, Lordship.
Oh, that would not be relevant, madam.
Yes, Lordship.
You tell us one thing.
Yes.
Do you hail from the family of the landowners?
Yes, Lordship.
You do. And then do you also dispute the fact which the learned single judge obtained through a report which was summoned
Lordship.
that 2 persons were already given appointment
Yes.
on that basis?
That is the crux of the case, Lordship. The other one is already that person approached this honorable court, and by the direction of this honorable court, that appointment was given. Chopi 1, Chopi. The other second one, Bokatoli, which they are claiming is she never applied on land or honor basis, Lordship. Even her appointment order, even her application is annexed in the reason with petition. She applied in general category, never in land honor basis. The land honor basis application carries that I am the land owner and I ought to be given this so and so post in great purpose. That is how here it is settled precedent, Lordship. Now, that lady never applied on land ownership, Lordship. So, and in their report also, they have already shown that 3 persons donated the land. Now, Lordship, only 1 person is appointed. The second one I am disputing is that Srimati Bokatoli, whom they have submitted in the inquiry report, she never applied under land owner basis. That is the crux of the case, Lordship. So, the second, and we have to be appointed 3 individuals donated.
Madam Jimumi,
Yes,
there is a report submitted.
Yes.
It is at page 74
Lordship.
of the memo of appeal.
Lordship.
Pursuant to this report submitted before the learned single judge,
Lordship.
did you file an objection or anything on record by putting it on record, anything?
Yes, Lordship, I have.
Which is your pleading for that?
I have.
Where have you said this in your memo of appeal? That you objected to this information which was provided on a report which was called for?
Lordship, in my.
That was not taken into account.
Lordship, I have annexed affidavit in reply to that.
That is, annexure is not part of the pleadings, no?
Lordship.
You have to say that. You realize the importance of it, no? Annexures there are so many documents which you have annexed with the memo of appeal.
Lordship.
But unless you make a specific disclosure that this was brought to the notice of the court and which was not considered, how do we refer to it in our appeal? In the appeal before us? Because that fact does not, from the judgment impugned in the present appeal, that fact does not appear to have been taken notice of by the learned single judge. We would have asked them to respond to this charge, but then you have not made that part of your pleading.
In the judgment order, Lordship, of the single judge.
No, while framing your memo of appeal, while framing the ground, you should have said that this report is incorrect. It is with respect to one of the appointees, you should have said that that appointment was made in a general category and not in the category of landowners. Just put in the, but it's an affidavit, no? They have to. That's right, before the writ appeal, there is a memo of appeal that was heard. It's true, but then in memo of appeal, there should be a ground. This document was not considered, because this is not PD. Now, this was an election. In appeal, they have to say that this was not considered. Anyway, we'll give them time. So what we intend to do is this. Now, you need to file an additional affidavit in this appeal and make it a ground. And then we shall put it to respondent number 5 and the state to respond.
Lordship, additional affidavit. Lordship, will,
I think you have followed what we are saying.
in the contention,
Have you followed what we are saying?
Lordship,
And you also have to tell us, where has the learned single judge erred in holding that the place where you want appointment, that place has not fallen vacant. You would be entitled to an appointment under the landowner's quota in the subdivisional office, not in executive engineer's office.
Exactly.
So therefore, that also you are required to contest.
Lordship, I have contested and I have even.
No,
annexed.
we don't find annexure is something else. Therefore we may bring it to your notice. There should be a ground in your memo of appeal that even though it was brought to the notice of the court, it was not considered.
Lordship,
Then only, because we are not sitting in regular appellate jurisdiction.
Lordship.
See, the law with respect to writ appeals is that unless the judgment impugned is perverse or bad, suppose a different view is taken by the appellate court, that is not the only ground for setting aside the judgment impugned.
Lordship.
There has to be a total rebuttal. I mean, if you don't transverse, the doctrine of traverse applies clearly.
Lordship.
So you have to put in an affidavit and
Lordship.
say that this was what was pleaded by you, but not taken into account. And then we will ask them to file an affidavit in view of what has been said. 10, 11 they have said.
Lordship,
Just a minute. A memo of appeal. Yeah, you've said that. Yes. You've said that, madam. You are not pointing it out. You've said that. You've said that very clearly. Huh? Good that my brother pointed it out, but we don't look at the memo of appeal, no?
I don't want to rebuke my lordship since my lordship is here today.
No, it's all right. You need to respond. Respond number 5, you need to respond.
Your lordships.
Take that. We have heard the learned counsel for the parties. You put in their names after receiving the slips. The claim of the appellant has been rejected by the judgment impugned on 2 grounds, namely that under the land owner's quota for appointment, 2 persons have already been appointed. And therefore, there was no question of disturbing the appointment of respondent number 5. This statement in the impugned judgment was based on a report which the appellant contends is not factually correct. This aspect of the matter is required to be responded to by respondent number 5. Let the requisite affidavit be filed within a period of 2 weeks, whereafter this matter shall be listed for final determination. All right. Give a date.
Lordship.
We'll decide. We are not admitting it. We'll decide it straight away.
Lordship, Published.
Not to add burden to the docket. We'll decide it on that date only.
Highly
All right,
obliged.
yes. It's over. I is in the first matter, first set of matters, all delays, IAs, those are disposed of. Separate orders. Now, just show it to brother. Oh, is this the regular number of cases listed?
We normally have more cases, Your Lordship, but the Lordship also has some other responsibilities along with.
All right. So this is a concession to the Chief Justice for his appearing today for the first time, huh?
Here we have a division bench on only on Wednesday.
Okay.
So tomorrow you'll get it, sir.
No, tomorrow I have to be early. I have to leave.
But I mean, normally it's there. So other days is single, so there's no date fixed on Wednesday.
Okay. All right.